What is one way to quickly get an attorney to tell you, nope, they can't help you with your medical malpractice case? Want to know the answer to the question? Stay with me as I share with you this very important information. Hello, I'm Marcus Boston, and I'm a medical malpractice and childbirth injury attorney practicing law in the state of Maryland, and I would like to talk with you today on this gorgeous day here in Coco Cay in the Bahamas. I'm down here on a cruise. I've got a bar function that I'm doing, and I want to take this quick moment to talk with you about one of the quickest ways to get an attorney to essentially tell you, no, they cannot help you. And that quick way is to have what we call unreasonable expectations as to your case. Now, you may be asking yourself, Marcus, what do you mean by unreasonable expectations? This can take place or it can take form in a lot of ways. And one of those ways can be a client expecting you to have a medical malpractice case wrapped up and completed in, let's say, a couple of days or a couple of weeks or a couple of months. That would be an unreasonable expectation in many instances. And that is because these types of cases take a long time to get through. You've got to get the medical records. You've got to analyze those records. You have to have experts to look at those records. Got to interview the client. There's a lot of things that have to take place. And if the client has unreasonable expectations about their case, then that's a good way to get an attorney to say, I can't help you. Another way we can see unreasonable expectations is, let's say you've got a case, and I'm gonna switch it up a little bit. This is not even a medical malpractice case, but let's say you've got an auto collision case. And the attorney thinks that the case is probably worth, let's say, $100,000. But the client, for some reason, believes that their case is worth $1 million. See, that would be another case of unreasonable expectations. And anytime you're dealing with things like that, an attorney is more than likely going to turn you down for your case. Because if it's unreasonable, if you want the attorney to do something unreasonable, or you have these unreasonable expectations, then more than likely that attorney is not going to take the case. The attorney actually should not take the case. So why have I taken the time today to talk with you about this really important information? Because I'm trying to give you insight into the Maryland medical malpractice process. I'm trying to help you understand some of the things that an attorney is going to analyze when we're talking about bringing these types of cases in the state of Maryland. If you have more questions about your situation, maybe you're watching this video right now because you were injured, and you were injured because of something that you think that your medical doctor or that the hospital may have done. Or maybe you have a child that has suffered an injury, a brain injury or some other type of injury at birth, and now you have questions about what's going on. If you have these types of things going on in your life and you would like to speak with me further about what's up, then this is what I invite you to do. And remember, it costs you absolutely nothing to take this next action. And what is that action? To pick up the phone and give me a call. I can be reached at 301-850-4832, or if you prefer, you can send me an email to medicalinjury@bostonlawllc.com. I answer Maryland medical malpractice and childbirth injury and wrongful death questions just like yours all the time. And I will be happy to take some time and listen to your story. All right, that's going to be it for today's quick educational video. Again, I'm Marcus Boston, and I'm one of the medical malpractice and childbirth injury attorneys here at Boston Law Group, LLC. And we will see you next time. Take care and enjoy the rest of your day.